Ladies and gentlemen, let me welcome you warmly on this quite sunny Polish and Brazilian afternoon, Polish afternoon and Brazilian morning. And well, a very warm welcome to the English-speaking part of the team and una cálida bienvenida a nuestros estimados colegas de España. Uma calorosa recepção aos nossos estimados colegas do Brasil. And the public announcement is here my Spanish and Portuguese, and hopefully, because my pronunciation probably sucks. So, folks, we've got a lot of speakers today. Our first speaker will be Professor Dariusz Szostek from the Opole University, so my home university now. And the title of his presentation is LegalTech 1, 2, and 3, New Proposals from the European Commission. You've got generous 15 minutes for your presentation. So, Professor Szostek, you've got the floor. Okay. Professor Szostek, I think your microphone is off.
Okay, in this moment it's okay?
Yes, it's okay.
Okay. Also, good morning, good afternoon for all. I think it's the best hello. Sorry for my English, it's not very good, but Portuguese and Spanish is worst. I will speak, I think, about 5 minutes. No more is so much lectures. LegalTech 102030 and new proposal for UA Commission. What is now? What is the LegalTech? LegalTech, the concept of LegalTech is at the moment not currently reflected in the legal definition. In nothing law in Europe, I think in Brazil too. At the moment, it is a doctrinal concept understood differently by many authors. Every authors have self definition. But it's the broadest understanding that is the concept is understood is at its solutions that include both hardware and software utilized in the law. In 19 years, last century, it was only marketing definition for USA products for liars. I think that the best definition is from Professor Martin Ebers from Germany. The application of LegalTech come in various forms and shapes, beginning with the infrastructure connecting clients with lawyers, through automation of drafting documents or the services to algorithmic decision making. And what is at the moment LegalTech 1, 2, and 3.0? There are 3 stages of legal technology indicated by academic literature, only in academic, not in the law. LegalTech 1.0 is very old and refers to technology, including software that supports the work of lawyers as professionals. Those are not new solutions. Yes, for example, document drafting and production, normal MS Word, legal information system, yes, expert system, and video conferencing. Now we have video conferencing, online communication with the courts, online trials, online education, and more states have only LegalTech 1.0, Poland 2. LegalTech 2.0 relates to the far more advanced technology, not only supporting lawyers, but also substitution itself for the work of the humans and automation to the acts of the token. For example, it's fact-finding or fact assessment, automatic document, contracts or client drafting, smart contracts, and tokenization of process. On Poland, we don't have these products. We don't have this LegalTech 2.0. And final, sometimes speak that is the future in Poland, yes, but in the different country is now in now time LegalTech 3.0. In the scope of which automation and substitution of human by technology is not the crux of the matter. The possibility to make autonomous decision by algorithm. And now European Commission looking for the problems with the legal tech and with the algorithm. And now from last months, we have two very important propositions. That is for regulating algorithm in LegalTech 2.0 and 3.0. What is the first? The first is the proposal for regulation laying down harmonized rules on artificial intelligence. The draft includes definitions, very, very important and very interesting definition for algorithm, for AI. Principles of responsibility for AI, control of the codes, and regulation covers not only AI, but also machine learning and special interesting expert systems. And the second totally new proposal is for last week is the ADAS tool. And the draft included the concept of a European single digital identification, European ID, completely new idea, credentials, and definition of an electronic register. That is very important because that is the first legal in the Europe law legal definition, not in the normal country, European definition, blockchain. And it's an idea for a legal presumption of entry in an electronic register. Yes, there are also proposals now in Europe for the digital era, regulation of electronic service, cyber security, that is very important, data and government, and more. And I think that is very short, and more in my monograph. Not mine, with more authors edited by me and Professor Zawadzki. In summer in print and open access by Nomos. And now we open a special science platform, Legal Engineering EU. Now it's in the Polish, but in English version be in the summer. Thank you very much.
Thank you very much, Professor Szostek, for your dynamic, short, and interesting presentation. I think we'll have a question and answer session at the end of this panel. So let me introduce our next speaker, Dr. Agnieszka Kubiak Cyrul from AFM Academy in Krakow, and she will be talking about smart contracts as a lawyer's working tool. Professor Cyrul, you've got the floor.
Thank you very much. I hope you can hear me, you can see me. Yes, no problem. If there are any problem, please give me sign, because sometimes we don't notice this. So I would like to take this challenge and say something about smart contract as a lawyer's working tool, which is not easy task because it's already quite developed in legal doctrine. So the plan for this very short speech will be first presenting blockchain and smart contract technical definition, just to explain you how it works. because we are talking here about quite new technology, then I will try to show the benefits and the limitation resulting from the use of smart contracts as a tool of automation of contract performance. And then I would like to show you some possibilities of using smart contracts in lawyers' work, because it's actually happening. So there are companies which are using this in the activities. And at the end, I would like to show you some problems which we see on the borders between law and this new technology. This is really something very interesting for lawyers. When we have to start from blockchain, because this is the platform for the smart contracts. So the platform, which is called blockchain, is a kind of infrastructure technology that enable a peer-to-peer instantaneous exchange of value digitally. This is really important to understand the mechanism which is behind this technology. It is a kind of shared database or shared ledger on which current state of data is confirmed and verified without the need for a trusted centralized authority. It is a variant of a distributed ledger technology. There is no one definition currently, but I particularly like this simple explanation that blockchain is made up of multiple and identical copies of the same ledger shared by multiple parties. So we have the very special structure. It's built, it consists of many components, and the key components are here provided. I will not explain how they work, but they are very important for this technology. And because we don't have time to explain how it works, I just would like to say how this blockchain technology is different from existing technologies, why it's so interesting. First of all, it is said that it provides a single source of truth. It's because it has a distributed character, so it means that the verified data are distributed to participants on the network, so that multiple parties have the same record of data in the same time. It has a decentralized character. It means that the maintenance of the network, including also the data verification, does not depend on a centralized authority. And here I would like to underline that I'm talking in this presentation only about the public blockchain without other possibilities. And the most important thing, which is the most important characteristic of this technology, is that this technology is temper resistant. This is it means that the verified data are cryptographically secured. This provides a high degree of data integrity and immutability. And of course, it is transparent. We may see, using, of course, internet connection, we may see blockchain, public blockchain, and it's fully auditable, which is quite important element. And on this platform, on this blockchain working as I described, we have a smart contract. The term smart contract was first used by Nick Szabo in 1996. So it was used before the blockchain was created. But of course, this technology flourished only when the blockchain actually was a widespread idea. When we are talking about smart contract, we are thinking about the contract in a legal sense, but it is not a contract in a legal sense. It is a kind of self-executing code which is deployed on the on the blockchain, and it works in a certain way. So when predefined conditions, predefined in this algorithm, which is behind this, a smart contract, when these predefined conditions are met, a smart contract execute a set of actions as agreed by participants involved in the creation of this smart contract, which then was implemented in blockchain. So I would like to underline that this is not a contract in a legal sense, but of course it can be used as a implementation of the legal contract provisions. So it can be the next step toward the automatization of the contract. We know from the history, we had these attempts to automate a contract, not only concluding the contract, but also performing the contract. We had the vending machine, we had this very interesting idea of Ricardian contracts, and now we may say that smart contract will be the next step in this direction. Application, smart contract application now. Of course, smart contract is a kind of technology which extends the functionality of blockchain. First, the blockchain was used to transfer the currency, Bitcoin, and that was the main type of smart contracts which were concluded or which were deployed in this platform. But now smart contracts can be created in completely a different way. It can be presented in the form of applications, and of course it completely changed the way how the blockchain can be used. A smart contract, especially in blockchain Ethereum, are used to execute terms of contracts as well, not only in a traditional way as it was before. And they use the application of this way of business activity, because it is connected with a kind of business logic, is really widespreading now. Here you have the list of blockchain companies, and you may see many household names, important players in international trade and finance and etc. So it is already happening. There are clients who are investing lots of money in this technology, and they will need lawyers who will understand this technology, and lawyers who will be able to advise them. I would like to show you some examples of the smart contracts which were deployed on blockchain. Here you see the flight delay insurance provided by AXA under the name of Fizi. It was, of course, a demo action, let's say, but quite important because it shows how it can work in practice. It has a form of smart contract which automatically pays out without the consumer having to make a claim, using a reliable data or source of flight delay data, and of course it shows that we may automate certain types of contract, and this type of contract is quite easy to automate because we have this source of very reliable data. This is example of a smart contract which was actually used for this insurance Fizi. This is a contract source code. You see that this is completely different language. When we are looking on this, we are seeing just the numbers or symbols, but this is the way how the natural language of the contract was translated into the machine language. And this is the first thing which is for lawyers very important to understand, that we are dealing with completely new language, that maybe it will be useful in future to be able to understand, or at least maybe not understand the code, but have the idea how it works. This blockchain on which these transactions, this insurance are register is also provided in an open access. So each transaction which was concluded was actually registered in the and then revealed in these records which are accessible for the public. This is also a very important feature because it really gives this the idea of a total transparency when we are using this technology. So to summarize, when we are talking about advantages of the smart contract technology, first of all, automation of the execution of certain provision of the contracts. We have to also accept that not all provisions of the contract may be automated. Transaction security, reduction of transaction costs, standardization and transparency, as I already said, are among the most important advantages. But we have to also see the challenges of this technology. This technology, smart contract, is deployed on blockchain. So there is no need to trust anybody in this relation because everything is written there in this blockchain in the form of algorithm. There is no need to trust in a single entity. But of course, this is this software, this algorithm, and we have to trust the software. And here the problem starts because smart contracts are written in this machine-readable language, which is beyond the control of the lawyer. So the lawyer who actually is advising his client is not able to control the way how this execution of the provision will be realized, performed. This is really something we have to keep in mind. So smart contracts not performing as intended is a major risk. There are certain intention of the parties which are expressed in the contract, and then when we are trying to implement this in the code, then maybe sometimes we will have the problem with keeping this intention valid. And in the same time, we have to also remember about the vulnerability of the software. And this feature of the software code can be exploited. So code can be badly written simply. It can have mistakes or problems. Then we have security issue. Sometimes we will have bugs. Software, we cannot guarantee that this is the product is free from bugs. Can be hacked, or we may have mistakes in the code as well. And the last problem, which is really important, is the problem of Oracle. Oracle is a technology which enable it enabled the contact between the real world and the blockchain. So we may treat the Oracle as a source of external data. And if we don't have trust Oracle, then we may have poor data, and this data will be fed to smart contract, and then we may have a problem with the performance of this smart contract. So there are some problems which are quite important, and when we are taking the perspective of the lawyer, we will have the problem with determination of the contract content of the contract, because we don't know the algorithm, we don't know the code, we don't know how to code, we don't understand the mechanism which is behind this. We have the problem with actions which are taken by this smart contracts under the influence of error, for example. A problem of liability for errors in code. Who is liable, the coder or the other person? We have to look closer. And the problem of the capacity to act, to capacity to conclude the contract and perform the contract. This kind of technology will be used also by minors, and what then? Another problem, rigidity of the terms of the contract written in code. It is written in a machine readable code, so it has to be simplified, because you cannot express in the code everything what we have in our natural language. So it results in a certain rigidity. And the lack of possibility of modifying contractual provision expressing in code, or when it is already deployed in the blockchain. We cannot touch it, we cannot change it, we cannot amend it. We may simply add another block to the blockchain, but this what we already have then it's untouchable. The problem with GDPR, the problem with the famous right to be forgotten, is inherently incompatible with this immutable nature of the blockchain. And of course, we may avoid this problem if we are not using personal data in the structure of the smart contract. So there are some ideas how to avoid this problem. A problem of changing external circumstances after the contract was concluded, and what then? How we may change this, what was already written in the smart contract and deployed on the blockchain. And the problem with, again, the relation between natural language and the machine readable language. How should due diligence or good faith be described in the code? It's simply impossible. Machine cannot read this or cannot perform this. How to code for termination rights when there is a contract and we would like to terminate. There are some problems, and the problem related to the consumer rights, the problem of unfair contract terms, which could be automated and included in a smart contract, or the problem of right to withdraw from the contract, which the consumer possesses. And the last problem is, of course, the problem of jurisdiction and applicable law, which is completely a different story, and of course it is very much related to this subject, because we are talking here about the globally accessible solutions, technology. So it is really important to understand that the lawyers will have to change their even education. There is a big discussion now. Maybe we should change the way the program in the law school. Maybe we should add this element of LawTech. Maybe we should teach also the coding for lawyers, just to give these young lawyers the idea how in which environment they will be working after the studies. Thank you very much, and I will give the voice to Piotr Stec.
Thank you very much, Agnieszka. Well, it was a wonderful presentation. We've got time for questions at the end. So just a short remark. Yes, we should do the coding, we should do the maths. And you know, there are even textbooks on statistical analysis and probability for lawyers. So perhaps we will start teaching lawyers calculus 1 on 101, and it would be wonderful. People would not study law anymore. Okay, so we've got our third speaker, this time from Spain, from Universidad de Vigo. So I will try my Spanish, my non-existent Spanish again. So nuestro próximo ponente será un estimado colega de la Universidad de Vigo, Jaime Aneiros Pereira. You've got the floor.
Okay, thank you, Professor, and good afternoon in Europe and good morning in Brazil. Well, my communication is based on under the opinion that some directives promote the LegalTech. One of them is the directive of the protection of persons who report breach of European law, the whistleblowing directive. Whistleblowers play a key role in the exposing and preventing the threats or the harming of the interests of the European Union. One of the forms that the legal system can protect the whistleblowers is the anonymation of the communication for the companies or the public administration. Indeed, the directive promotes two ways to conserve the privacy in the communication about the facts that the whistleblowers communicate to the compliance officer or the direction of the companies or the direction of the public bodies. One of them is the internal channel for reporting, and the second one, the most important, I think, is the external channel of reporting. Why? Well, the external channel of reporting in a company or in a public body can be a procedure, can be a way to facilitate, to promote the communication of the suspicious transactions, the doubts about some operations or some behaviors of the persons. The fact is that under the external channel can be a professional, can be a lawyer, can be a counsel or anybody that study, that use also databases to check the facts, to check the correction of or not of the behavior and the communication of the whistleblower, and also conclude that it's okay, the operation, or if there is a bad information that can be used for other persons. Okay, so the external channels for reporting under directive is, I think, a tool, and an important tool to preserve the privacy of the whistleblower, but also to allow to professionals, as professors or consultants or lawyers, to work to a company or to work to a public body, and to use databases and another legal and technical tools to analyze, to study, to confirm or to say that the behavior of the whistleblower is wrong. So I think it's a new way to work in this century to promote these communications in the internal, within the companies or within the public bodies. This is in the line of the other directives of the European Union. As we know, in the tax matters, the DAC 6 and the directive of the professionals that can disclose their operations to the public administration, to the tax administration. So we have two roads to discover the fraud, to discover the conducts are forbidden by the law. One of them is the whistleblowing directive, and another one is the disclosure of the operations that applies in the tax system, in the tax consultants, and tax advisors. So in both cases, the tax administration or the administration use also a technology, also blockchain that can preserve the anonymous of the communication and can preserve the origin of the communication. So under my opinion, we have a new way to understand this new use of the technology, also to understand the new use of the professional services in some cases, and we have a new I mean a new field of dedication for consultants, for lawyers, for tax advisors to analyze the operation, the communications, to study operations, and to aid to the companies or to the public bodies to resolve the doubts of the legality or not of some operations, or the behavior of some workers or public servants. So in some cases, the duty of confidentiality of this external channel, the processing of personal data in this external channel, and the record keeping of the reports in these external channels, I think is a point that shows that we have a new legal tech in this new century. This is a short and brief resume of my article. That's all. Okay, thank you very much.
Muchas gracias. Thank you very much for your presentation. And we are coming back to Poland and back to the AFM University and Professor Kamil Szpyt, who will discuss the legal challenges of using the Internet of Things in the insurance industry. Professor Szpyt, you've got the floor.
Thank you very much, Professor. I'm time and ready. Give me just a moment to share my screen. Could you see it?
Yes, we can.
Okay, thank you very much. So, ladies and gentlemen, usually before starting the substantive part of my presentation, I'm in the habit, probably like most of you, of thanking the organizers for the invitation. In this case, however, it would be a bit strange taking into account that I myself am a member of the organizing committee. Therefore, instead, I would like to say that it is a pleasure to see you all today and to welcome you, even if we meet only a virtual. So, at the same time, I'm afraid that after such excellent presentations, as we have already had a chance to hear, those of Professor Szostek, Dr. Kubiak, Cyrul, and of course, Professor Pereira, I will not be able to present anything more interesting. In this situation, I have nothing else to do but to at least try to not bore you. So, some definition. Moving on the topic of my presentation, Internet of Things. Internet of Things does not have one universally accepted legal or doctrinal definition, neither in Polish law nor in a European Union law. A fairly accurate definition of the Internet of Things has been created by the authors of the European Union Commission staff working document on the free flow of data and emerging issues of the European data economy, accompanying the document Communication Building a European Data Economy. So, in this definition, Internet of Things is a wide-ranging ecosystem of physical objects connected to the Internet, capable of identifying themselves and communicating data to other objects with the help of a communication network for digital processing. In other words, the smart devices that make up the Internet of Things ecosystem use built-in processors, sensors, and communication equipment to collect, send, and use the data they acquire from their environments. This data is sent to the cloud so that it can be analyzed, or it is sent to the devices communication with other connected devices and act on the information they pick up from each other. Importantly, the devices do most of the work without human interventions. There are already many real-world applications of the Internet of Things in the automotive, telecommunication, transportation, and medical industries, among others, of course. And it's not necessarily about some spaceships or humanoid robots. Imagine an old-fashioned refrigerator which sent an order to the store as soon as it sensorily detects that a certain product is missing or in short supply. For example, a product so important for survival as beer. I think male listeners gathered in the front of screens would agree with me. For me personally, I think it's like a modern day Aladdin's lamp, which additionally doesn't need to be rubbed. Yes. So, all right. And what use can the Internet of Things have for insurance? So these uses are quite a few, but the most important ones are estimating insurance risk for accuracy, precise of course, offering more individualization insurance, and prevention of some insurance events. Excuse me, claims, of course. At first, so let's start with the first two issues. And as an example here, we can point to the us of the Internet of Things to verify the skills of certain drivers in order to offer them lower insurance premiums. We will be dealing here with so-called telematics. The basic element of a telematics system is the installations of monitoring devices in the policyholders' cars, which allows sending, receiving, and storing telematic data, such as GPS data, and as number of other data characteristic for a given car, the speed of given driver, the areas where he drives, etc., etc. And then transmits this data to the central server, and the server interprets the data and allows it to be displayed to end users via, for example, secure websites and apps optimized for smartphones and tablets. To give you an idea of the magnitude of this phenomenon, suffice it to say that according to a report by Berg Insight, there was 27.5 million insurance politics linked to the telematics tools in the North America and of course in Europe at the end of 2019. So, third one, another area where the Internet of Things can be used in the insurance industry is to prevent certain insurance claims, for example, those caused by fires. Some insurers already offer their customers special sensors that are placed on the electrical systems in the house. And if there are increasing heat causes, for example, by a short circuit, they inform the appropriate system, which allows to significantly reduce the risk of a fire. And unfortunately, as life experience teaches us, everything that is good and innovative must give rise to some legal problems and gives us lawyers a chance to earn this magnificent fridge that will order a beer by itself for us, yes? In the case of Internet of Things, complications are currently related primarily to the lack of comprehensive and uniform regulations on the international or even pan-European scale. Second, cybersecurity of devices incorporated into the Internet of Things. And third one, risk of violations of data protection regulation as a result of using the Internet of Things. So, first, lack of regulations. Poland, in general lacks special regulation for internal things. At best, regulation belonging to 4 different groups can be used in this case, concerning cybersecurity and personal data and intellectual property and civil liability. And a similar situation exists in the European Union, although here the first attempts at regulations are already appearing. Of course, this raises the questions of whether the internal things can be regulated by a single comprehensive piece of legislation. The answer to this question posed in this way should be in the negative. The issue are too diverse to even think that it can be done. However, it is worth considering the implement of certain basic general acts that would later be further clarified by specific provisions, whether from the particular area of law or simply sectoral provisions. And in the case of the largest and the most significant sectors of the economy, it is worth recommending to introducing of certain codes of good practice. It seems that the insurance industry is just one of these industries. Cybersecurity, another problem that can arise in the context of using the Internet of Things in the insurance industry is the risk of using Internet of Things devices for hacking attacks. And this is not just a theory, it is worth recalling the history of famous Japanese washlets. It is devices that are a combination of toilet, both, and a bidet, of course. As you may know from movies, the interior of an average Japanese toilet often resembles the interior of a spacecraft, which is steered not by radars, but by a smartphone. It allows you to turn on the water, hit the toilet seat, and turn on your music, of course. And so, this one, excuse me, and this has been proven in practice. This system can be hacked quite easily. Now, imagine this situation. You are sitting in the toilet, busy with your own affairs, and suddenly, for example, Ride of the Valkyrias is playing from your toilet, yes? Da, 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 dum, dum, da, 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 dum, dum. Yes, of course, you will say it's nothing scary. On the contrary, it can motivate a person to extra heroic effort. Excuse me. This is true, but what about when, instead of heroic music, a hacker lets you water from a bidet in the situation where you don't expect it? A full stream of water when you are on the toilet during the break in the important meeting, for example, yes? And another example, a successful attempt to hack the light bulbs on the well-known manufacturers, which allowed them to turn off against the will of the owner. Now, imagine that instead of those bulbs, your car's lights were turned off at night during a very difficult road. So, or as a bad joke, the sensors that test for overheating cables were turned off too. So, as you know, the insurance industry is one of those industries that processes huge amounts of data, especially personal data. They concern, among others, health of the insured, their age, past operations, accidents they were involved, etc., etc. Their lack of age can cause really serious consequences. At the same time, it seems that many times these data are not properly protected and processed. Of course, officially, all products are fulfilled, yes? IT specialists are paid, etc., etc. But as we say in Poland, the devil is in the details. For example, at the end of the last year, a large Polish insurer, Warta SA, was punished by the Office for Personal Data Protection with an administrative fine for sending an unsecured policy to the wrong client and when failing to take the necessary steps to minimize the negative consequences of such an act. This year, in turn, one of the broker's firms accidentally shared the medical data of one of the clients, which was reported by one of the portals dealing with the cyber security. And here the questions arise. What is the security of a personal data processing in the case of the Internet of Things in the insurance industry? Are insurers able to ensure adequate procedures here? Of course, everything should be approached with the appropriate distance, of course. So, firstly, many times the Internet of Things systems will only connect to the specific receiver, which means that there will be little chance of data leakage outside this network. Secondly, even if such data leaked, it often does not have to particularly sensitive. For example, the already mentioned results of our firewall sensors. Yes. However, there are exceptions. For example, information about the route of our trips coming from the sensor in our car. Useful for thieves, useful for kidnappers, useful for example, jealous wives. Leaking this information can have really terrible consequences, especially in this later case, this third one. Okay, ladies and gentlemen, summary. As you can see, there is no shortage of legal problems related to the Internet of Things. Unfortunately, most of them do not yet have solution. And unfortunately, I do not have enough time to find them. And so this is, by the way, in line with my life motto. I always give 100% at my presentation. 10% Monday, 23% Tuesday, 30% Wednesday, 22 Thursday, and 5th Friday. And since it is Thursday, the missing 78 of the work to find the answer has to be done by one of you, ladies and gentlemen. And in this moment, I thank you for your attention.
Thank you very much for your live presentation and for your 22% of effort. And well, having thought about the fridge example, it's one of my worst nightmares. I am a big person, as you probably have noticed. So my worst nightmare is that I'm trying to open the fridge and the fridge says, no, no more food for you, go on diet. So our next speaker will be Professor Pavel Koukal from the Masaryk University in Brno. No, I will not try my Czech, it always ends wrong. So, Professor Koukal, you've got the floor.
Okay, I hope that you can hear me well and
that
you can see me also. I thank you very much for allowing me to participate to this conference, and thank you, Mariusz, and also other organizers for our fruitful cooperation. Let me also announce that the cyberspace conference, which is regularly held in Brno, it will be held also this year in a hybrid mode. So those who would like to come are more than welcome, and those who would like to present online, they will be allowed to present as well. So my topic today is about the platform liability under the DSM directive, and how is it also somehow connected to the notion of copyrighted work. So let's start speaking about the joint liability. I will generally speak about the tort law issues concerning with the safe harbor and also with the implementation of the DSM directive. So if we are speaking about the IP infringements on the internet, we see that the right holders often find it difficult to file lawsuits against the actual infringers. And for this reason, the attempts are often made to take an action against third parties who, although they are not direct infringers, have nevertheless somehow contributed to the infringement, so they have indirectly caused it. And here we can speak about the joint liability. So if several persons jointly cause the infringement, they are liable as joint tortfeasors. And in some jurisdictions, the condition or requisite for this is only the intentional. It means conscious and deliberate cooperation, which leads to a mutual attribution of the contributors to the act. And here we speak that the participants, either assistants or auxiliaries, are liable as joint tortfeasors. However, Czech law and also German law applies also a different concept of joint and several liability. This is inspired by the German concept of secondary infringers, in German Nebentäter, and in English we call it as several concurrent tortfeasors. And here this means that a person or persons who jointly participate in the occurrence of damage are jointly and severally liable. In the Czech law, it's covered by section 2915 of the Czech Civil Code. But the nature of their liability may be different. So the damage is caused by separate acts, but while the primary infringer, here the user, acts intentionally, the secondary infringer may act negligently. So here we assess whether he or she acted with the due care. Now let's have a short look to the secondary infringement. In terms of German legal doctrine, we call it as Störerhaftung. And because the German doctrine is very important also for the Czech civil law, because the Czech delict law is highly influenced by the German BGB, the concept of the IST liability in the sense of Störerhaftung can be applied also in the Czech civil law. In Germany, it's based on section 1004 of the BGB, which represents a fundamental principle or norm in the whole area of property rights. In the Czech Civil Code, we have similar provision in section 1042. And in Germany, the term Störer, it doesn't necessarily identify the person who has violated another property's right, but the person who is called to protect it. And breach of duty, this Störerhaftung, is a special form of third-party liability for indirect infringement outside the category of the direct infringement or participation. So under this concept, the delict can be attributed also to the indirect infringement if the infringer violated a general duty of care which is imposed upon him or her. As it is generally known, and I suppose that also you know, that the liability of intermediaries is limited by the so-called safe harbor limitation, which is provided at the European level by Article 14, paragraph 1 of the e-commerce directive. And from the tort law perspective, the safe harbor is not a circumstance which precludes the illegality, like when we speak about the tort defenses, such as consent of the victim, or for example, copyright exceptions and limitations in the field of copyright law. But it is a requirement of the standard of care that the ISP must exercise in order not to act negligently. So generally speaking, the ISP loses its safe harbor as soon as he knows about the unlawful content and doesn't act upon it. It's so-called actual knowledge. Or if he should have known about the unlawful content, this is so-called constructive knowledge, and he hasn't acted with a required duty of care. Now let's have a look how the DSM Directive Article 17 can be put into the this concept of duty of care, because we can say that the Article 17 applies the new rules for liability regime as ISP liability is concerned. The EU member states that are obliged to transpose Article 17 of the DSM directive now face problems how to consider the requirements of the directive in the context of their national tort laws, and also in terms of copyright protection. And in this respect, well, the tort law considerations, which I have described, might be useful. Because, why? Because the examination of the requirements of duty of care comes only after we examine the circumstances precluding the illegality, so these tort defenses. So that is why Article 17, paragraph 1 and 2 of the Digital Single Market Directive requires content providers to have the consent of the rights holders. This is the level of circumstances precluding the illegality. And as a second step, we must examine whether the intermediary has met the requirements of professional care, which is then stipulated by Article 17, paragraph 4 of the Digital Single Market Directive. So, in my opinion, Article 17 of the DSM Directive, in particular, its paragraph 4, introduces a new duty of care requirements. So the intermediaries, the ISPs, they have a primary duty to act in such a way as to obtain the consent from the right holders, and thus avoid the illegality of the content which is communicated to the general public. But at the same time, in addition, they are also obliged to make every effort to ensure that the subject matter which is communicated via their platforms is communicated with a requirement of duty of care. And now let's have a look to protectable subject matter. So when we go back to these basic tort law principles, we must always assess when we speak about the Article 17 if or not the content is really protected by the copyright law. Because Article 17 will only apply if protected work or other subject matter is whether it is protected by the copyright protection. And on the other hand, Article 14 of the e-commerce directive, well, it has a broader scope of application because it also concerns, for example, trademarks or registered designs or patents. And in this view, we must also take into the account the case law of the European Court of Justice, the most current decisions, which brought to the conceptual or definitional features of copyrighted work this new or novel requirement of the sufficient precision objectivity. So we must always assess, according to the Lebola-Hengelo decision, Kofemal decision, and Brompton bicycle, whether or not the creative outcome has been expressed in a sufficient, precise, and objective way. And only in this case, we will then consider the application of the Article 17 of the DSM directive. So thank you very much for your attention. And at the end of the session, I am looking forward to possible questions.
Okay, so thank you very much for your presentation. And it's nice to see that we still need old-fashioned civil law in the new technologies sector. So let's move forward to Brazilian presentation. So nostro próximo orador será nuestro estimado colega, Professor Mateus Sant'ana. Our next speaker will be Professor Mateus Sant'ana from the Universidad de 9 de Julio, Brazil. So you've got the floor. Yes, I know I mispronounced it. So you will tell us how should we pronounce the name of your university. You know, the same problems I have with Norwegian colleagues. We had a colleague whose name was, we thought, as German speakers, Bergen. So someone decided to ask him how to pronounce his name, and it was something like, ugh. So it's always tricky, but please remember, I'm doing my best.
Right.
Voice.
Thank you. Oh, sorry. Everyone listening? And
yep.
Listening good? All right. So my name is Mateus. I'm from Brazil, from University of 9 July in São Paulo. With my partner, my professor, Renata, we write this paper. Sorry, unfortunately, but she now have another point, and she's a judge in the Court of Justice of São Paulo. So she's not now, but we work together. So I'm apologize about my presentation. I do all in Portuguese, so I'm gonna try and speaking in English in the presentation. The name the presentation is the consumer's right of choice in the face of the internet search engineering. I'm not seeing my presentation right now, Leonardo, but if you can put excellent. Now it's better. You can put, yes, the first one, please. Primeiro, por favor. Vou colocar. Obrigado. Isso. Obrigado. Sorry, I told you I'll write all my presentations in Portuguese. But in the end, if someone have any questions, I can answer, it's no problem. Movimento de expansão no comércio eletrônico se manteve mesmo durante na pandemia, na crise da pandemia no Brasil, né? Então, esse é um dos grandes motivos que chamou a atenção dessa pesquisa, né? Então, the expansion of e-commerce has continued to grow up in diverse countries. Specifically in Brazil, the pandemic, the COVID-19, not stopped the grow up the e-commerce. And that the specific point is the e-commerce had a system. Sorry, let me put the presentation. Right now it's back. It's true that make gateway the electronic markets, the internet search engineer system, also called search engineer, or search tools, which are offered by companies, example, Google, Yahoo, Bing, among others. Então, o motivo da nossa pesquisa foi também explorar a parte do comércio eletrônico, né? Onde os sistemas de buscadores de internet, também chamados aí os motores de busca de ferramentas, são oferecidos aí por diversas big techs, como a Google, Yahoo, Bing, entre outras, destacando aí, então, a pioneira que a gente trabalhou mais no trabalho, que foi a Google. Leonardo, pode passar por gentileza? Can you pass, please? O slide pode passar por gentileza? Thank you. I bring that this notice in Portuguese is about a journal contact from Luxembourg, version in Portuguese. The France punished Google in over 2,000 million euros for dominant position in internet. Eu trouxe essa mensagem, essa notícia, para contextualizar um pouco o nosso trabalho, a nossa pesquisa, com uma notícia do jornal Contato luxemburguês, a versão portuguesa, onde a França ela foi multada em 220 milhões de euros por abuso de posição dominante na internet, né? Utilizando aí dos algoritmos aí que estão por trás dessas ferramentas de buscas, né? Pode passar por gentileza, Leonardo, can pass, please, the presentation. Thank you. A autoridade, então, da concorrência francesa autuou ao Google em 220 milhões de euros por esse abuso, e a sanção é o resultado de uma negociação em que a Big Tech, né, norte-americana, aceitou as acusações e assumiu uma série de compromissos na sua política de publicidade que se tornam obrigações que foi explicada aí pela autoridade francesa. Então, o centro da questão está a posição dominante que a Google tem nos servidores em relação aos anúncios para os editores, os sites, as aplicações móveis, que permitiam um tratamento preferencial no próprio uso de suas próprias tecnologias, né? A exemplo aí o Google Manager e Google AdWords, né? I bring this notice about the punish of the Google and the France, for example, and over 2,000 million euros for a punish for this legal and publish online. So, pode mudar por gentileza, Leonardo? Thank you. With the technology advance, search engineers have become more advanced because they difference adversary from organic response, for example, and the adversary directed by algorithm, which that internet user when access, for example, the Google search. Sixteen, the fact the algorithmization program and not the organic result of the search and the consequence putting at the risk the declared with the consumer. Então, o motivo maior de trazer esse trabalho, essa busca, foi que os sistemas de buscadores, eles tornaram-se mais avançados, né? E através de modelos de negócio, a própria Google pôde diferenciar, então, a publicidade de resultado orgânico, né, que eles chamam, e publicidade diferenciada pelos algoritmos, em que consiste aí em acessar aí a vontade do consumidor através do Google Search, por exemplo, aonde o algoritmo ele programa a vontade do consumidor. Então não é um resultado orgânico, ou seja, aquilo que o consumidor propriamente se deseja, como consequência aí a gente tem propriamente dito uma violação da declaração do consumidor. Então assim busca-se então direcionar esses anúncios ou serviços similares e induzem o consumidor médio a agirem sem sua vontade. Então é necessário que haja um respeito à escolha da legislação consumerista, né? Então, this search engineer attempt to target the similar products or service which induce the average consumer to act without their will. It's necessary to respect to consumer choice, the important legal regulation, because from the moment that a company that was a larger part of the search, so that's the point, the protection. Leonardo, pode passar por gentileza? Oh, thank you. Então, é importante a regulamentação jurídica, né, como eu estava falando, que a partir do momento que uma empresa como a Google é detentora de volume de busca realizada na internet por meio de ferramentas, ela desenvolve, então, esse modelo de negócio voltado, então, ao oferecimento desses anúncios para os internautas. Então, torna-se preocupante aí o poder de impacto diretamente, né, que essas big techs, não só a Google, elas possuem em relação às outras empresas, né, não só big techs, mas também as próprias empresas que anunciam na internet, né, porque a Google ela cria a ferramenta, então ela tem a linguagem e a gente tem um problema aí de transparência dos algoritmos, né? Então esse é o ponto específico que tem que ter maior atenção. Então, a partir desse momento em que há um algoritmo direcionado para a vontade do consumidor, como ocorre, por exemplo, com o produto da Google AdWords, fica claro o potencial aí de limitar o exercício do livre direito à escolha do consumidor, usando, então, o exercício de atividades da própria empresa, que são lucrativas, que é o modelo de negócio, né, que é a venda dessas palavras-chave, que são palavras-chave que são vendidas por esse serviço, para que quando o internauta faça a busca, seja direcionado para o site, né? Então, somado aí ao exercício da atividade lucrativa, voltado ao oferecimento dessas palavras-chave a serem adquiridas pelas empresas, então, a fim de alavancar a atividade de vendas, né, dessas empresas, e, consequentemente, pode causar, aí, como havia mencionado, uma prática desleal, né? Então, it's necessary to respect the consumer's choice, né? It's important legal regulation because from the moment that company like Google had a large part of the volume of search, like the name of the big data, né? The performance and the internet started to develop a business model offering the address to internet users. It's because offering and service. This from the moment that there is an algorithm directs the consumer's will as a Google address, for example, which a clear potential to limit the through consumers' right choice and added it to exercise of lucrative and active, and often the keywords should be a cry for competition or company in order to the active in the electronic commerce and consequently exercise unfair competition practice. O Leonardo pode mudar, por gentileza? So the method for research used in this research for work is an inductive bibliography and jurisprudential research. Então, o método utilizado nesse trabalho de pesquisa foi o indutivo, né, com pesquisa bibliográfica e jurisprudencial. We separate in two parts. The first one, the e-commerce and the engineers system. The second part, the business plan and the freedom initiative. And you can change, pode mudar, Leonardo, por favor. And for conclusion, os buscadores algoritmos, né, especificamente no caso aqui da Google, que inclusive o Tribunal Europeu, o próprio Tribunal de São Paulo já tem diversas decisões jurisdicionais se posicionando já sobre essas concorrências desleais e prejudicando diretamente aí o consumidor e a atividade empresarial, né? Então, a gente observa-se aí que é necessário respeitar a escolha do consumidor, então, para que haja aí o uso desses algoritmos aí, ele pode utilizar, mas desde que haja aí uma transparência aí nas informações, que o consumidor saiba e tenha esse acesso, que ele está sendo ofertado, né, essa prioridade no serviço, né? Também é importante uma regulamentação jurídica, pois a partir do momento que uma empresa detentora de grande parcela de volume, como eu já mencionei, que é o caso dessas Big Techs, né, utiliza esses modelos de negócio voltados ao oferecimento dessas vendas de palavra-chave para impulsionar os anúncios dos consumidores internautas, torna-se aí preocupante aí essa ausência dessa transparência aí, porque pode afetar diretamente a concorrência dos mais diversos setores da circulação de bens e serviços, né? Então, the search engineering algorithm is the present case intended to direct to advertising of the similar products of service, inducing to average consumer to act without their will. It's necessary to respect to consumer choice. It is important legal regulation because the create regulation in Brazil, for example, because the moment that a company like Big Tech, Google, to develop a business model and offering the advertising internet use, it's become worrying. It can direct impact of competition in the most diverse sectors of circulation of goods and services. So the consequence of the absence of legal regulation can cause a potential indicator to limit to free exercise of the consumer rights of choice. So if someone has any questions, I will present and answer the questions. Se alguém tiver alguma questão, eu fico honrado em poder responder. Mais uma vez, daí peço desculpa pela ausência da professora Renata, ela está no evento do Tribunal de Justiça de São Paulo nesse momento. Agradeço mais uma vez o apoio de toda a organização do evento, em especial o Leonardo, por ter ajudado em todo momento da apresentação, ter tido bastante paciência comigo. Agradeço também a brilhante organização do evento. Os temas são importantíssimos. E a Uninove, a Universidade 9 de Julho, que faço parte da organização. Agradeço também todo o apoio que foi dado aí. Obrigado, atenção. Desejo uma boa tarde. Thank you for attention for all. Thank you for organization for event, the brilliant event. Special Leonardo for help me all the time in changing my presentation. My pleasure sharing of one, and the professor Renata Maciel is now she's present, she said right now, but thank you for attention one, and especially for Uninove, the University of 9th of July for helping together. So have a great afternoon. Thank you again. Appreciate.
Okay, thank you very much for your presentation and the chance to brush up yet another language. Okay, thank you also to Professor Renata Maciel. We all know what it is when the court says, yes, you have to wait. So where we are all, our good thoughts were in you in that court. Okay, so our last speaker, because Professor Fras unfortunately will not be able to join us this evening, will be Professor Victoria Tavares de la Valentina from the Pontifical Catholic University of Rio Grande do Sul in Brazil. Dear colleague, the floor is yours.
Hello, I'm sharing my screen. Do you see it?
Yep.
Which one? Wait, let me. Do you see it in full screen?
Yes, so it's perfect.
Wait, So my name is Victoria. I'm from Pontifícia Universidade Católica do Rio Grande do Sul, and my work is about legal practice based on design thinking and agile methodologies. The agenda for today, I'm going to talk about, I'll make a little introduction, and then I'll talk about design thinking and Kanban, and then I'll present my framework about design thinking and Kanban. So the problem of my research is to develop a framework that gathers together the design thinking and the Kanban. My methodology is based on an empirical approach to study these parts and an exploratory purpose, and based on a bibliographic review procedure. Oh, sorry. Okay, so I'll start talking about design thinking, and its main value is the human need as a starting point. So it's based on the problems, and it seeks the solution for specific problems from the client. And it has also a value of a multidisciplinary team. So in the case of lawyers and also maybe developers and designers, in case, for example, of smart contracts. So it gets together lawyers and developers. It has to be in a creative environment, and it has iterative processes. So the approach, it's based on three main phases. So the first one is the inspiration. It talks with the client to seek solutions from the problem. And then the second phase, it would be the idea. So it's based on brainstorming, and you get as many ideas as possible to seek for the solution of the client. So it's based on the human needs. It's based on the problem. And after the idea, you test the idea. So you gather as many questions and as many ideas as possible, and you test them to see which one is the best one to solve the problem of the client. And the third phase is the implementation, when you take this idea to the market. And later on, recently, the authors are talking about 7 phases. So these phases are already in the third phases, but it has more details. So the first phase would be to define. So you talk to the client, you define the problem, and then you research about the problem, and you seek as many ideas as possible. In the third phase, generating ideas, also based in the brainstorm, and then you test these ideas, which is the test prototypes phase. And then after testing the ideas to see the viability of them, you select the best ones to implement, and you try to implement the ideas. And after you take them to the market, it's the last phase where you learn about. You take all the results these ideas has brought, and you learn about it. And this part is this main importance of this part is that you have more material and more content to the research part, because if you have another project, you can take these results and also use in the research part of the next project. So the Kanban, it's an agile methodology, and it's I'm going to talk about what agile methodology is. So it was created in the late 90s, where a few developers reunited because of the problems they were seeing in the market based on the waterfall model. It's also known as the classical model of designers and of software development. And it's based on the waterfall model, which is the handle, the lever of the software or of the product only in the end of the project. So it has everything done, and then it takes to the client the material. This has problems because only after you finish the product, the client sees the problems. So you have to do everything again, and it's more expensive and takes more time. So these developers developed a new methodology, which has 4 objectives and 12 principles, and they are based on solutions and incremental delivery, which is you have lots of phases to deliver parts of the product to the client's test, and then to see if it's okay to continue or you have to do it again. So you lose less time because you have already seen the problem, and you lose less money because you don't have to do everything again after you have done it. So the main part also is to add value at each stage. So each of the parts of the software or any project, you have to add value. The Kanban is one of these methodologies. We have others like Scrum or XP, and it's based on a Toyota model of production, and it has what's called a pull system. They don't have Toyota's model doesn't have a storage, so the work is all based on the demand. So they have to work only when they have a demand, and it has 3 essential pillars, which is the visualization of the workflow, and an adaptive development, which is they adapt the development of the product based on the demand, and they have the limitation of the work according to the flow, and the flow is dictated by the demand. Okay, so this is Kanban. This is how it works. It has it has a dashboard with 3 columns, which is to do the main things you have to do to the task. The second would be the doing, where you do, and then the done, which is when the product is ready. So you have all the things to do, you put here. Let me just okay. When you have to do, you put it here, and then when you are doing, you change the tasks in the dashboard so everyone can see what you are doing. And then after you have done it, you put it in the done. So you can control your work, and everyone can control what is being done and what's left to be done. Because this is not a hierarchical procedure, and everyone can know. So you can identify the problems of your production to see what is going on. So I suggested a framework based on Kanban and design thinking, because we see problems in the legal practice today that it can be solved using these tools. Yeah. So the first part would be the design thinking part, where you have to put you have the contact with the client. So you define the problem, you know what the client needs in the legal practice case. So, and then you research, you generate the ideas, also based on the design, on the brainstorm methodology. And then you put the 7 phases of design thinking in the Kanban dashboard. So in this case, for example, we are testing already our idea. And so to test the idea, we have already to define, we already have to have the problem, we already have to have done the research, and we already have to have the ideas generated. We have already the brainstorm, because sometimes we, in the legal practice, at least to me, we have the ideas, but we may not have the complete idea. So when we are doing the job, we remember something, or we have an insight, and this could be prevented in the brainstorming when we reunited the team and the leaders and everyone to think about a specific case, and then you start doing. So you improve the quality of your work and also the time usage to do the work. So this is my idea for the implementation of design thinking and Kanban in the legal practice. And I hope you have enjoyed it, and I'd like to thank you for the attention.
Thank you very much. I think you got lost part of your connection. So, folks, we've got information that Professor Frass will not be able to participate today. He was stopped by something important. So. It's Vismayo, and well, the floor is open for questions. So if any of you would like to ask our presenters a question, it's the right time to do it. You can do it by typing the message, okay, in the chat. It would be the easiest way, or please simply raise your hand. Okay. And yes, the questions can be posed in the working languages of the conference. Please don't be afraid to grill your colleagues. It's a part of university tradition. So if there are no questions so far, I will be the one who starts. And I have a question to Professor Kubiak Cyrul. Agnieszka, I was thinking about, yes? Okay, Agnieszka, I was thinking about your thesis that we've got a problem with smart contracts because you don't know how to rescind them, modify them, etc., etc. And my million-dollar question is it really a legal problem, or it's just a programmer's problem? So my job as a lawyer would be to create a specifics for the IT crew in a way they know that they should include small things like modification, rescission, and that some contracts will end at the end of the day. So I would like to know your opinion. Okay.
Maybe now we will have a good connection. I'm sorry, but I had to turn off one of our computers which are in this room. Thank you very much, Peter, for this question. I was actually thinking about this problem. But as I see this in practice, we as a lawyer assisting our clients in implementation of these new technologies in the process, in the business process, we should be able to explain things to them. They will probably understand less than we from this process, and we should be able to guide them as well. Of course, there is a problem of communication between IT people and the lawyers. We have different goals. IT people, they have different goal to reach when they are preparing algorithm, and we as a lawyer, we are trying to translate the intention of the parties into this automatic execution process. So we should communicate and we should cooperate, and we should learn how to cooperate, because we are using different language. We are using different, maybe the meanings of the language, it will be different for both sides. So we should start to look for a common understanding of the process. And it will be useful if we could be prepared, maybe during our studies, to this cooperation. And that's why I underline at the end of my presentation that maybe, you actually continue this idea. Maybe we should learn a little bit more about the technology during our study, because we will be using this technology. We will be advising our clients on this technology in their business.
Mm-hmm.
Thank you.
Okay, thank you very much for your answer. And I see that Professor Koukal is raising his hand, so you've got the floor.
Yeah, thank you very much, Piotr. I had a question to Kamil Szpyt, because he had a very interesting presentation concerning the Internet of Things. And he mentioned that we need more regulation, or probably more specific, or maybe also more comprehensive regulation. But I wanted to ask, is it really so that we need new regulation for these new technologies? Or is it better to apply the current principles of civil law, either in the field of contract law or tort law or property law, and to adapt them to this new situation and new emerging regulations? Because, for example, when we look to the GDPR, which is a very comprehensive regulation at the EU level, I really don't think that the GDPR made the data protection better. It provided a lot of duties to a lot of subjects, but I don't know whether we can say that the position of the data subjects is so much better than before. So this is what I just wanted to ask, Kamil. Is it really that we need new comprehensive regulations, or probably to try to find a way how to use our civil codes, copyright acts, and so on, and to adapt them to the new technologies? Thank you very much.
Pavel, thank you very much for this question. So, in my opinion, could you hear me? Yes. Okay. So, both solutions are acceptable. I think so. It's certain that changes must be slowly. Evolution, not revolution. But which road is the best in these cases? I think so. We can discuss about it. The new regulations are not necessary, but I think so. It's good start for these changes. maybe some very general regulations about the Internet of Things.
Thank you.
So thank you very much for your answer. Do we have other interventions? No, if not, well, I will be, I take my liberty as the host of this panel to ask our last speaker about the possibility of using the Kanban and agile methods, not necessarily in everyday legal practice, but in legislative studies. So would it be possible to imagine a, say, agile legislative process? With design thinking and stuff.
I'm sorry, I have a bad connection. Could you repeat?
Okay. So once again, I was thinking, is it possible? Would it be possible to think of agile legislation or design thinking legislation as in using the agile methods and design thinking in the legislative process, planning the law, testing it, executing. Okay.
Okay. I think more about the private practice of legal designers, or also the design thinking, but the legislation part here in Brazil, at least, the process is very bureaucratic, and it takes a long time most of the times. So it would be interesting to add this practice in our legislation, and I think it's possible. You have to want to do it, but it is possible.
Okay, thank you very much for your answer. Okay, so do we have other questions to our panelists? Don't be shy. The last chance to grill them. Yes, again, Professor Koukal.
Thank you.
Pavel.
I just want to raise this question, which was in my mind when I heard the Agnieszka presentation. Is there anything specific concerning the smart contracts with regard to international private law and the law applicable to contracts? Are there any issues which need to be somehow, for example, newly conceived, newly regulated than we have in, for example, Rome 1 regulation or traditional rules of private international law? Thank you very much.
Okay, I will try. Do you hear me?
Yes, we do.
Okay. Yes, this is the one of the problems which we are always have to test or debate, and there is already the answer because some time, and after certain doubts, we I think we have the common answer that the rules we already have, we may also adapt to this this technology, because the problem of extraterritoriality of this technology is present, and we already had this problem in many other cases. So probably when we will start to use it in on a mass scale, maybe we will have problem with actually enforcement of the rules according to this private international law. But For now, we don't have the cases, so we don't know how it will work. Yeah, thank you.
Okay, thank you very much for your answer. Any other comments, interventions? Don't be shy. No. So if there are no more comments, answers, additional questions, short presentations disguised cleverly as questions, so let me thank you very much for your participation on behalf of the organizers. Let me thank all the speakers and all the viewers for their attention. I hope it's not the last time we meet. So I hope that next time we will be able to do it in a more hybrid form. So we will have what is the essence of a conference, party, mingle, chit chat, and perhaps a beer or two or wine or whatever is your poison. Okay, so anyway, this panel ends in a moment. So please choose other panels. Please remember tomorrow we've got the second part of the conference. And well, for those of you who are in Brazil, it's still early afternoon, so you've got plenty of time to enjoy the day. For those of you who are in Poland, well, it's 6 o'clock, so we are very close to dinner time and the final drink. Okay, so we've got one more message. So panel 5 will be in the same room. So those of you who stay for panel 5, please stay here. So it's all from me for today. Enjoy the rest of the conference and see you in the future. Goodbye.